Ready?
Good evening.
Good evening, sir. Good evening. At the outset, I welcome all the attendees and also our today's guest speaker, Honorable Justice V. Gopalagowda, sir. And I request the uh, opening remarks and further to be taken over by our Secretary, Dr. Suriraju, sir.
Thank you, sir.
Thank you, sir.
Good evening, respected Justice Gopal Gowda, sir. Our esteemed today's speaker, our President, Dr. Veerbhadra, sir, and Dr. Praveen Ramchandra, moderator, and Dr. Sri Shailesh Amirked, Chairman, Medico Legal Subcommittee, and all the office bearers, senior doctors, and IMA members. On behalf of IMA Karnataka State Branch, I warmly welcome you all to this today's Medico Legal webinar. As you all aware, medical negligence is one of the most important and sensitive issues faced by the medical professionals. Understanding the legal aspects help us practice medicine with a greater confidence, responsibility, and patient safety. We are very privileged to have Justice Sri Gopal Gowda, sir, Honorable Supreme Court Judge retired, to enlighten us on this important topic. First and foremost, I want to congratulate our legal subcommittee for electing such a very nice topic, which is helpful for each and every doctor. And the medical negligence is become a big issue. I'm confident today's session will provide valuable legal insights for every medical practitioner. Thank you for all joining. I wish you the webinar a grand success. Jai, long live IMA. So let us start this program with IMA prayer. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಪ್ರಾರ್ಥನೆ. ಎಲ್ಲರೂ ಸಂತೋಷವಾಗಿರಲಿ, ಎಲ್ಲರೂ ಆರೋಗ್ಯವಾಗಿರಲಿ, ಎಲ್ಲರೂ ನೋವಿನಿಂದ ಮುಕ್ತವಾಗಿರಲಿ, ಎಲ್ಲರೂ ದುಃಖದಿಂದ ಮುಕ್ತವಾಗಿರಲಿ, ಎಲ್ಲ ಆಸೆ ಅಂಶಗಳನ್ನು ಮೀರಿ ಗುಣಪಡಿಸುವವರು ನಾವಾಗಿರಲಿ. ಧ್ವಜವಂದನೆ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ರಾಷ್ಟ್ರಧ್ವಜಕ್ಕೆ ವಂದನೆ ಸಲ್ಲಿಸಲು ಇಲ್ಲಿ ನಿಂತಿದ್ದೇವೆ. ಅದರ ಗೌರವ ಮತ್ತು ವೈಭವವೇ ನಮ್ಮ ಬೆಳಕು ಮತ್ತು ಶಕ್ತಿ, ಮತ್ತು ಅದರ ಪಥವೇ ನಮ್ಮ ಪಥವು. ಈ ರಾಷ್ಟ್ರೀಯ ಸಂಸ್ಥೆ ಮಾನ್ಯತೆ ಪಡೆದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ಜವಾಬ್ದಾರಿಗಳನ್ನು ಅರಿಯುವ ಮೂಲಕ ಅದಕ್ಕೆ ನಮ್ಮ ನಿಷ್ಠೆಯನ್ನು ತೋರಿಸುವ ಪ್ರತಿಜ್ಞೆ ಮಾಡುತ್ತಿದ್ದೇವೆ. ದೇಶ ಸಮೂಹಗಳ ನಡುವೆ ನಮ್ಮ ರಾಷ್ಟ್ರಧ್ವಜವು ಉನ್ನತ ಮಟ್ಟದಲ್ಲಿ ಹಾರಾಡುವ ಸಲುವಾಗಿ ನಮ್ಮ ಅಧಿಕಾರದಲ್ಲಿರುವ ಎಲ್ಲವನ್ನೂ ಅದಕ್ಕೆ ಸಮರ್ಪಿಸುವ ಪ್ರಮಾಣ ಮಾಡುತ್ತಿದ್ದೇವೆ. ಜೈ ಹಿಂದ್. IMA ಚಿರಾಯವಾಗಿರಲಿ. ವಂದನೆಗಳು. I request our President, Dr. Veerbhadra, sir, to say a few words about this today's webinar.
Good evening, everyone. Thank you, Dr. Suriraj. Yes, Dr. Suriraj mentioned nowadays many of the doctors are facing cases against them regarding medical negligence. There are two different medical negligence and complication. What is complication? What is negligence? It has to be delineated separately. So, hope our speaker, well-known Justice Gopal Gowda sir, will deliver best and educate our doctors not to. Thank you very much and welcome, sir. Thank you.
Yeah, I request Dr. Sri Shailesh Amirked to introduce our Honorable Justice.
Yes, sir. Yes, sir. Dear members, it's a profound honor and a distinct privilege to welcome our esteemed speaker for today's session, Honorable Justice V. Gopal Gowda, sir, former Judge of the Supreme Court of India. Known widely as the people's judge and a judge with a heart, Justice Gowda's career is a testament to the power of the law as a tool for social transformation. Born in Karnataka, he rose through the ranks of the legal profession with a steadfast commitment to the marginalized, serving as a standing counsel for numerous trade unions and All India associations before his elevation to the esteemed bench. His judicial journey took him from the High Court of Karnataka to the helm of the Orissa High Court as its Chief Justice, and ultimately to Supreme Court of India. Throughout his tenure, he has been a fearless guardian of constitutional values. Perhaps most notably, his landmark judgment in the Singur land acquisition case remains a cornerstone of jurisprudence on land rights in our country. Beyond the courtroom, he is a profound thinker and academic at heart, having served as a professor of law for many years. He is a staunch advocate for the principle that constructive dissent is the bedrock of a healthy democracy. In an era of evolving legal challenges, his voice remains one of the most rational, humanistic, and courageous in the Indian legal landscape. His previous roles, as I mentioned, were in the Chief Justice of Orissa High Court and Judge of Karnataka High Court. And his core focus is on labor rights, land reforms, social justice, and constitutional ethos. I request Dr. Mr. V. Gopalagowda to present his views about the topics selected by us. And I also request Dr. Praveen Ramchandra, moderator of our session, as well as the legal subcommittee member, to take over the further events. Thank you, sir.
Hi, good evening, everyone. Respected Honorable Justice V. Gopala Gowda, sir, esteemed office bearer of Indian Medical Association Karnataka State Branch, and distinguished colleagues and dear participants joining us from across the state. It is my great privilege and honor to welcome you all to today's webinar organized by IMA KSB Medical Legal Subcommittee. Medicine today is advancing at unprecedented pace. Yet alongside these scientific advances, the medical legal environment has become increasingly complex. Every day, doctors are expected to make critical decisions under time pressure, often with incomplete information while balancing the patient expectation, evolving the standard of care and legal accountability. The adverse outcomes does not necessarily imply negligence. However, the distinction between an unfortunate complication and legally actionable negligence is often misunderstood not only by the public but sometimes within the medical profession itself. Today's webinar addresses the three questions that are both timely and highly relevant as of today. First is, does the medical negligence compensation claim survive even after the unfortunate demise of the doctor? If so, what is the legal position regarding the liability of the family members, the estate liability? And the second focus will be on how do courts determine the quantum of compensation in medical negligence cases. Understanding the principle behind the compensation enables the doctors to appreciate how judicial decisions are reached. And third would be, what practical steps can every doctors take to reduce medical legal risk while continuing to provide ethical and compassionate care. So whenever the case doctors been facing, how he has to handle the situation. These are not merely legal questions. They are directly influence the confidence within the doctor practice medicine every single day. To guide us through these important issues, we are privileged to have with us a distinguished jurist whose judicial career has been marked by unwavering commitment to constitutional values, fairness, and justice. It is indeed an honor to welcome Honorable Justice V. Gopalagowda, sir, former Judge of Supreme Court of India and former Chief Justice of Orissa High Court. His vast judicial experience and deep understanding of constitutional and civil jurisprudence make him uniquely qualified to illuminate these three important points. Sir, on behalf of the Indian Medical Association, Karnataka State Branch, all the participants present today, we extend our warmest welcome and sincere gratitude for accepting our invitation, sir. With this, I welcome Sir Justice Gopalagowda, sir, to start the session, sir. Thank you.
Thank you, doctors. Dr. Veerabhadraya TA, the president of IMA KSB, Dr. Surya Raju V, Honorable Secretary, IMA KSB, Dr. Sri Shailesh Amarkad, Chairman, Medico Legal Subcommittee, Dr. Praveen Ramchandra, Member, Medico Legal Subcommittee, and my dear doctors who have been participating in this video conference. The Indian Medical Association, Karnataka State Branch, has chosen very relevant and important topics to be discussed, deliberated, understand, to help out to discharge for discharging your professional duties as doctors. My understanding of doctors is you are the saviors of the humanity. The recent trend, medical negligence cases have been on the higher side. To mitigate the same, the and discharge your professional work, you must also understand the legal parameters on how to discharge your professional duties in the hospital to the patients cautiously, carefully, and skillfully. These three important topics day to day will confront you to a number of doctors across the universe. More particularly in India, this compensatory law after the Consumer Protection Act 1986 has been enacted and come into force in India. Number of medical negligence cases have been instituted by the affected victims. The doctors who are discharging, you are also be held responsible and liable to pay the compensation is the law, and that is the legal position today insofar as the consumer law. The first topic I would like to deal, that is, do medical negligence compensation cases continue after a doctor's death? Family members are liable. The answer is yes. This is based on the judgment, latest judgment of the Supreme Court in Kumudlal versus Suresh Chandra Roy, reported in 2026 SCC online, SC page 797, has comprehensively analyzed this question of law and has found the answer to the same in the affirmative. This is the latest judgment of the Supreme Court. The appeal was filed by the legal heirs after Dr. Lal, the alleged negligent doctor, against the order of the National Consumer Dispute Redressal Commission. The application under Order 22 CPC, Civil Procedure Code, by the legal heirs praying to drop the names from the proceedings was rejected. The case of the legal representatives of the said deceased doctor was that since the complaint was dismissed by the State Consumer Dispute Redressal Commission and Dr. Lal, the legal representative's father, passed away during pendency of the revision, no formal decree of any forum or commission existed against him on the date of the death. After the death, Therefore, the proceedings ought to have been closed as abated, as no right to sue survive against the legal representatives. This is the argument of the legal heirs of Dr. Lal. The respondents in that appeal, that is the original complainants before the State Consumer Redressal Commission, argued that Order 22 CPC prescribes only the mechanism and procedure to substitute legal representatives, and the question of whether the right to sue survives must be answered by the substantive law. Findings of the court in that case is difference between the claims of personal injury. This is this distinction. Difference between the claims of personal injury and financial estate-based claims. Claims based on personal injuries, such as what is personal injury is explained here: defamation, pain, suffering, personal injury do not survive the death of the wrongdoer. 2. Claims of financial injury, such as costs incurred, economic liabilities, and pecuniary loss, which are enforceable against the estate of the wrongful doer, this is the principle, will subsist after the death of the wrongdoer against his or her legal representatives representing the estate of the deceased. For instance, a medical negligence case for compensation is claiming by the victim or their legal representatives operation charges, doctor's fee, cost of medicine, etc., and compensation of bodily harm caused, mental and physical agony, etc., only the first set of claims would subsist against the legal heirs of the negligent doctor. Subsistence right to sue and subsistence of decretal debt. What it means is explained here in this case. While the subsistence of right to sue depends on the aforementioned classification of personal claims, which I have stated just now, and financial claims, the subsistence of decretal debt is provided for by the Section 306 of the Indian Succession Act, 1885. For instance, if a defendant in a suit for defamation dies during the pendency of the suit, the plaintiff's right to sue does not subsist against the defendant's legal heirs. This is the distinction. Defamation suit. If a defendant is a party, he dies during pendency of the suit, such cases, the defendant's legal heirs are not liable. However, if there exists a decree against the defendant, the decree and the decretal debt form a part of the estate of the parties. If the decree is already passed, it has attained finality, then against the estate which left by the defendant, it is enforceable against his estate. For the estate, the legal heirs will succeed to the property if it is self-acquired property. If he is a Hindu Succession Act 1956, Section 8 applies. Therefore, if the defendant dies in a pendency of an appeal against the decree, his legal heirs are bound to be substituted in his place, as they are entitled to defend and uphold his estate. The said proposition of law is elaborated by the Honorable Supreme Court by referring to its earlier judgment in the case of Melepurat Sankuni Ejutusam Tekital versus Tekital Polan Kuttinaya, this is from Kerala state, reported in 1986, one SSC page 118. The principle laid down in this case at para 7 reads thus: where a suit for defamation is dismissed and plaintiff has filed an appeal, what the appellant plaintiff is seeking to enforce in the appeal in his right to sue for damages of defamation, and as this right does not survive his death, his legal representative has no right to be brought on record of the appeal in his place, and instead of the appellant dies during the pendency of the appeal. The position, however, is different, where a suit for defamation was resulted in a decree in favor of the plaintiff, because in such a case, the cause of action has merged decree, and the decretal debt forms part of the estate, and the appeal form decree by the defendant becomes a question of benefit or detriment to the estate of the plaintiff's respondent, which his legal representative is entitled to uphold and defend, and is therefore entitled to substituted in the place of the deceased respondent plaintiff. If the suit is dismissed, original court, then there is the matter. If the plaintiff, during the pendency, he dies, it abates. But if the plaintiff in the original suit decree is passed, against which appeal is there, at the time of hearing the appeal, if the defendant dies, his legal representative should be brought on record to oppose or defend the decree that will be passed. The legal maxim in this regard is actio personalis moritur cum persona. This maxim, which means personal right of action, dies with the person. Repeat. Maxim, which means personal right of action, dies with the person, was not applied by the court, as the application of the same in India has been statutorily modified by the Fatal Accidents Act of 1855, which is still in force. Legal Representatives Suit Act of 1855, Indian Succession Act 1925, etc. The same has been stated to be unworkable in today's social jurisprudence as per 178th report of the Law Commission of India. Nevertheless, the Honorable Apex Court did not establish liability of the doctor and adjudicated solely on the question of law. The court remitted the matter to the NCRDC to be adjudicated on merits, emphasized that substitution of legal representatives does not imply or establish liability. So this is the legal position insofar as the liability of the legal heirs of a doctor, deceased doctor, once it is not a personal injury. It is not a case of defamation. It is a case of the medical negligence, on account of which under various heads claims can be preferred. The money spent, money paid to the doctor, the expenditure incurred in the hospital, the future liability, the personal disability, so many aspects will come into picture that cannot be treated as personal economic liability, personal injury or economic liability. Yes, it is economic liability where on account of medical negligence, the cause of action survives and it is against the estate of the doctor. The legal heirs are entitled to succeed to the estate if intestate property. Therefore, legal representatives are liable to pay and defend the case. If his decree is made, the legal heirs are liable to pay the compensation, is the law which has been laid down after following the various other important legal aspects because it is a substantive right given to a victim or the legal heirs of the victim in India. This is the legal position so far as the first topic is concerned. Topic number 2, I'll switch on to the topic number 2. How is the quantum of compensation determined in medical negligence cases? Very, very important. What are the guiding factors? Has been explained by the Supreme Court in the case of Dr. Balram Prasad and Dr. Kunal Shah and others. I am the author of this judgment, reported in 2014, 1 SCC 384. This is the law which is still in force across the country. Various district consumer forums, state consumer forums, in respect of the medical negligence for awarding and quantifying the compensation, the guiding principles laid down in this case by the Supreme Court, to which I am a party and I am the author of the judgment. I have considered various legal aspects to determine the compensation. In this case, the uh, Supreme Court criticized the inadequacy of the multiplier method. Multiplier method is adopted in the compensatory law under the motor vehicles accident. There also negligence. The concept here also negligence, medical negligence. But in this Dr. Balram Prasad case, it has been held, criticized the inadequacy of the multiplier method, which was applied in no-fault motor accident cases, and adopted a more individualistic and sophisticated approach, incorporating inflation, the victim's qualifications, the potential future earnings. These are the aspects which have been taken into consideration in the case of Dr. Balram Prasad versus Dr. Kunal Shah. The principle of restitution in integrum, the current approach of the courts in computing compensation for medical negligence, is aimed at restoring the claimant to the position they would have been in if not for the negligent act. 2. Scientific calculation of loss of income. The Honorable Apex Court in the Kunal Shah case judgment considered the following criteria. Number 1, age of the deceased and the probable years of employment. Number 2, income of the victim. 3, inflation in money. Living / personal experiences. 1/3 of the income to be subtracted, deducted from the loss of the income calculation. 5, individual considerations like education qualification, prospective income, field of work, etc., are relevant factors to be taken into consideration by the forum to determine the compensation. Number 1, age of the person in the case of Alfred Benedict versus Manipal Hospital, reported in 2015 11 SCC Supreme Court cases, page 423. A 2-year-old girl developed gangrene in right arm due to an act of medical negligence, which resulted in its amputation. The apex court, considering the age of the child and her lifelong suffering, be it her education or marriage prospects, awarded a lump sum of rupees 20 lakhs. Percentage of disablement and functional disablement. Percentage of disablement and functional disablement are very important factors to be borne in mind by the forum or a commission to consider and award the compensation. The nature of the disablement, what is the nature of the disablement? For which medical evidence is most important to be placed on record by the victim or the legal representative of the victim, by the victim, not legal representatives, and how it affects the functionality of the victim has been taken into consideration by the court while assessing the percentage of disablement. Percentage of disablement depends, it is in the employees compensation law, there is a schedule. What is the percentage? Is the one arm or two arms or the legs, amputation? These are all various parts of the body or the head injury. What is the percentage, memory, etc. These are all various aspects will be is vividly explained way back in 1923, the Workman Compensation Act 1923. What is the percentage? So now you are well aware. The functional disability is based on what is the function which is lost by the victim is most important. That has to be determined. What is the functional disability caused on account of the negligence of a doctor and victim is suffering is the relevant consideration. For instance, this disfigurement of an actor's face has been viewed to be a matter of high disability as it directly affects their future prospects. This is the case which I have decided in the year 2014. Supreme Court, artist, the serial artist Sambalpur, she is from Kerala, in a motor accident claim. Her face was disfigured. I consider, the bench consider, face is an important aspect for an actor. Therefore, if face is disfigured, 100% disablement, functional disablement, because except the avocation of acting in the serials, no other avocation for earning or income. So therefore, it is 100% personal functional disability. It is a disability, 100% functional disability is the case which I have decided that holds the field even as on today. In Nizam Institute of Medical Sciences versus Prashant S. Dhanaka case, report in 2009, 6 SCC, page 1, the apex court also consider the enormous physical, financial, and emotional price paid by the family of the victims' disablement. Noting that a case of disablement puts the family in a more pitiable state as their constant anxiety, hurt, and despair that ensues every day throughout the rest of the victim's life suffer. Therefore, these are the various aspects which are required to be taken into consideration. These aspects must be vindicated in the claim petition as well as matter of evidence, as a matter of evidence, must be produced before the tribunal to claim the just compensation payable by the negligent doctor or hospital, and if the doctor dies, in his place legal representatives. If the hospital is also involved, because hospital will also be in the Kunal Shah case, substantial compensation. Liability is fixed upon the corporate hospital. What was granted, awarded against the doctors, 50% I reduced because though on record, substantial evidence was on record, there was a finding recorded by the NCDRC that the doctors were negligent in that case. It is the case of a the ailment treatment. She was a doctor in America. I awarded only 50%. If I would have awarded 100%, it would have run to some 20 crores in that case. But taking into consideration holistic view, doctors' negligence liability I reduced to 50%. That 50% is fixed on the corporate hospital of Calcutta. This is on the second topic. The third topic is general guidelines for the doctors on handling medical negligence. This is most important for the doctors who will be conducting surgery, giving treatment. They must be all the time must follow the standard of care and duty, the Bolam test. You are fully aware more than me. You will be aware what is the Bolam test. Adhere to accepted medical practice. A doctor is not negligent if he acts in accordance with the practice accepted as proper by a responsible body of medical professionals skilled in that particular art. That is Bolam versus Pre-Hospital Management Committee. 2. Exercise reasonable skill and knowledge. This is very important. If knowledge and skill are two different aspects, you may have the knowledge, you may not have the skill for conducting a surgery. So you must have both. You must have the knowledge on this subject and you must have the skill of conducting a surgery on a patient. Practitioners must bring to their task a reasonable degree of skill and knowledge. So it varies person to person. The exercising a reasonable degree of care is also most important. At the time of treating or at the time of conducting surgery, you are expected to take a reasonable degree of care. Absolute perfection or error-free outcome is not legally required. Absolute perfection or error-free outcome is not legally required. It is not possible to achieve that. Reasonable care, the skill and knowledge, treating a patient, conducting surgery are most important factor. So absolutism or error-free outcome, even in the legal profession or any profession for that matter, it is not absolute. The results cannot be expected. But whatever the care and knowledge on the topic, today what is medical knowledge? It all depends upon the research, the study is a continuous scientific research will be going on. For example, cancer treatment about 10 years or 15 years or 20 years back is totally different. In spite of the new inventions, new medicines, new therapies, the cancer, after the second stage, it will be very difficult to give treatment. Again, giving treatment to the patient, the stage at which a patient goes, that stage test for a doctor depends upon the pathological test of the body portion which is affected by cancer. So therefore, the doctors take a biopsy of that part, 2-3 slides, cytology. The doctors must give the report. That is the report on the basis of which the treatment course will commence. That's why all the time Earlier, it was not there. Diagnostic centers. The doctors used to give treatment on the basis of physical tests and symptoms which will be narrated by the patient. Treatment was being given. Now, science and technology is developed in the medical field. Today, every doctor will ask, please get the blood test, or if it is a diabetic patient, what is the H1BC, what is the position, and all these things, even for every viral fever also. Viral fevers are different type varieties. For that, the doctors will say, go and clinically test. Clinically test is blood test. Blood test report. Now, thereafterwards, if the strong resistance is there, which drug has to be prescribed, that is also required. So, the uh, absolute perfection or error-free outcome is not legally required. No limitations, no KNOW, no limitations. Practitioners should not undertake procedures or treatments beyond their skill level. This is most important. Being told these multinational corporate hospitals, they will tell you have to suggest the scanning, you have to suggest to implant the stent. If it is a heart patient, you must suggest surgery. All these things they will tell the doctors. That is unethical practice to make money. That is in the increasing side. That's why medical negligence cases are increasing, is the study today, according to me. It is the corporate hospitals who are responsible in causing medical negligence by making the doctors who go by the dictates. Otherwise, they will tell, no, no, you have to search for other hospital. This is what has been going on in the corporate hospitals. Unethical medical practices are going on, like in our judicial system also. A case which requires the remedy without knowing or making money for one case, they multiply 10 cases, the most unethical. This is going on. It is because the greediness, make money, easy money, that is not permissible. So this is the limitations you must know. The doctors must know their limitations. Practitioners should not undertake procedures or treatments beyond their skill level, except in life-threatening emergency situations. That you will be in a position to know it. If emergency demands that this procedure and all this emergency surgery is required to be done, you can undertake that, but not the uh, all the time to conduct surgery without conducting preliminary procedures and tests. Uh, the informed consent and patient communication, this is the most important aspect. There is a latest case which came to my notice. The two doctors specialists, the wife, she was 39 years old, engineer working in America. They came to the Hyderabad. Before traveling back to America, the medical test was required to be undergone. She undergone. Doctor said, there is a serious ailment. You are required to be undergo surgery. She was hale and healthy at Hyderabad. On the surgical table, on account of serious medical negligence, the part where they are required to conduct surgery, other than that part, they conducted, heavy blood was bloozed out and she went into the coma. Then the informed that patient is in serious condition. She did not come out from the consciousness, regained the consciousness. So she was in ICU for 48 hours. After 48 hours, she declared dead. In that case, some Apollo Hospital, this is Apollo Hospital, they claimed 100 crores, 200 crores compensation. The matter was pending before the NCDRC. Two expert doctors with reference to the case sheet and the surgery procedure, consent, etc. Two doctors, independent doctors on the topic, the ailment and surgery were examined. They gave opinion, independent experts' opinion. This is a clear case of medical negligence. Then they wanted, their evidence is most important evidence. Then they made an application before the NCRDC to refer the matter to the Indian Medical Council, the IMA hospital. They constituted a board. The board has given an adverse report, placing reliance upon the consent obtained from the patient. Consent will be taken for every patient, but consent is not the relevant criteria to determine medical negligence has taken place or not. For extraneous consideration, I am telling you with all seriousness and with information that medical board in the Indian Institute of Medical Sciences at Delhi, they gave an adverse report. Contrary to two eminent expert doctors' evidence, it is a case of medical negligence. So therefore, consent is a must. Consent by itself is not sufficient to arrive at a conclusion there is no medical negligence. Even in cases of consent, there are cases. Even in the case of consent, there is every possibility of negligence of conducting and treating a patient. Not only at the time of surgery, post-operation, there are negligences and patient will die. Post-operation care is most important. So, obtain informed consent. Ensure patients are clearly informed about the nature of the procedure, inherent risks, potential side effects, and available alternatives before initiating treatment. All these aspects must be strictly adhered to and followed. If it is not done, consent by itself is not sufficient to hold there is no medical negligence. 2. Respect patient's autonomy. This is most important. You have to explain to the patient. Respect patient's autonomy. Patient has got every right to say, I don't want the surgery. That's the autonomy ultimately prevails. Consent must be voluntary. She must voluntarily, you have to tell the patient, this is the ailment you are suffering, for which depends upon your age, depends upon the condition of the ailment, seriousness. You have to explain to the patient. That is, consent must be voluntary, given by a competent person. If suppose wife is in a not in a position to give consent, then the husband. If husband is not there, then daughter, major daughter. If daughter is not there, major son. Or if children are not there, the mother or father. The consent by a competent person is most important and specific to the procedure being performed. You must be specific performing the procedure before giving treatment or conducting surgery. Clear communication, that is, maintain empathetic and transparent communication Your communication must be transparent. It must be in writing. In the case sheet, you are required to record this is the procedure advice for this before the free surgery to be undertaken. After the surgery, post-procedural, the care must be advised and monitored by the doctor who treats or conducts surgery. This is most important. A significant proportion of medical negligence complaints stem from communication breakdowns. In this case, which I told you in Hyderabad recently, the doctors completely more than 12 hours they conducted because blood bleeding was there. They wanted to stop the blood bleeding. They did not inform. The husband was very much there. They did not inform at all. Then that is also they committed a blunder, committed medical negligence at the initial stage where they conducted the surgery. They were damn scared to communicate to the husband. They communicate to the husband and given a wrong impression, patient will revive. Blood bleeding is there. This is not because of the mistake of the surgery conducted by a doctor. Then it was found in the case sheet which part of the body they conducted the surgery was a wrong place. Complications started on the surgical table. So therefore, a significant proportion of medical negligence complaints stem from the communication breakdowns rather than actual clinical error. This is most important. Every stage, care and caution must be taken by the doctor and the hospital. Skill, knowledge, most are important. That should be exercised diligently. And communication to the patient relatives, it should be recorded in the case sheet. That's very, very important. In the case of Hyderabad, the case sheets they have to show that IME, the medical board report is bad, the case sheet speaks volumes. The case is coming up before the NCDRC. The senior counsel, I have requested him to argue the case because great injustice happened. 39 years old lady and two daughters, they are studying in America. They have no mother now. He is not remarried. This is the condition. Now, documentation and record keeping is most important. A doctor who treats must maintain the record. Meticulous record keeping is very, very important. Maintain clear, accurate, complete, and contemporaneous medical records, including the history, examination findings, consent forms, treatment plans, and prescriptions. In the case of Kunal Shah, the prescription of the drug is excess. We have seen the record. That is why the clear finding of medical negligence is the reason for awarding 6 crores and odd, including interest at the rate of 9%. It has gone up to 10 crores. That is the leading case in India today still, which is in force. Document non-compliance, explicitly record instances where a patient refuses recommended tests, procedures, or treatment against medical advice. This is LAMA/DAMA. Preserve evidence, the hospital and the doctors. The doctor who conducts the surgery or give treatment, you must have one set of papers with you. The hospital may, on account of the negligence, they may lose their record. They may say, you have maintained the record. Then, in the absence of the record, medical negligence is, that is only the test. The case sheet is only the document. Consent paper is only the document. What type of treatment you have given is the document. What type of surgery you have conducted, which part of the surgery, during the time of conducting surgery, what happened, everything must be clinically, it should be recorded. If it is not done, there is no evidence. Preserve evidence in the event of an adverse outcome. This is what exactly happened in the case of Hyderabad recently. Or notice of a complaint. Preserve all original medical records, logs, and consent documentation securely without any alterations or retro additions. After the patient dies, if the hospital authority or the doctor records overwritings, that is what is called retro additions, will draw an adverse inference that that has been fabricated. That goes against the doctor and the hospital regarding the medical negligence. A protocol in the event of an adverse outcome or error. What is the protocol required to be maintained? Prioritize patient safety. Immediate measures must be taken to stabilize the patient. What steps you have taken to stabilize the patient must be recorded, must be undertaken. Manage complications. How to manage complications? You must be in a position to know it on the surgical table. Seek higher level emergency assistance. If a patient at the time surgery, faulty surgery, then immediately higher level emergency assistance is required. If it is not done, again it is a medical negligence. A transparent disclosure. Disclose the facts of the complication or adverse event of the patient or their legal guardians calmly, factually, and without making hasty admissions of guilt. You need not admit the guilt. You have to inform. Your actions must be transparent. You must inform calmly, factually. What has happened, you must inform them. 3. Internal reporting. Promptly report the incident to the hospital administration, a risk management team, or legal cell as per institutional protocols. This is the duty of the doctors who conduct the surgery or give treatment. Complications arise, you have to inform the hospital administration, risk management team, or legal cell as per institutional protocols. Most of the cases, you know it, we know it, it doesn't happen. These are the aspects which they say, you call upon them, have you informed, evidence in the cross-examination, management, complications. Did you make alternative effect? How to get the assistance, emergency assistance? Whom do you contacted? What is the emergency, the higher level of emergency you thought of? Whom you contacted? These are all, these aspects will be elicited at the time of cross-examination, at the time of trial. So these are important. Professional and legal safeguards. Maintain professional indemnity insurance. You must insist the hospital. Maintain this indemnity insurance so that if anything happens, you will not be personally liable. The insurance will take care. Carry adequate medical indemnity insurance coverage tailored to be specialty and level of risk. You must ask the patient or the hospital insure. Depends upon the risk of the patient. Avoid unnecessary delay in referrals. We have to do it, the referrals without waiting. Avoid unnecessary delay in referrals timely referral cases to appropriate specialists or higher medical centers where a condition falls outside the domain of expertise or requires specialized infrastructure. 3. Adhere to statutory duties. You are governed by the regulation, you are governed by law. Adhere to statutory duties. Comply with the statutory reporting requirements for medico-legal cases, infectious diseases, and consumer protection regulations. Septicemia, patient, you must record it. What is the stage of septicemia and infection? It spreads to the entire body. Even the latest case of the cancer, my daughter-in-law's house, the lady who takes care of my granddaughter, at the young age, this fellow came into contact with the cancer. He went to Kidwa Institute. At that time, it was stage 2. They suggested to undergo surgery. Family members did not agree. Then he was treated, radiotherapy, chemotherapy treatment was given. Without undergoing the surgery, chemotherapy and radiotherapy will not give any result at all. Within a span of 1 year, he developed complications. He was taking Ayurvedic treatment at Chhattisgarh. 8 months back, he came back. 2 weeks back, my daughter-in-law requested me to do some help. I contacted the director of the Kidwai. I sent him there. He said, "Sir, I treated this patient about a year back. I told him to undergo surgery. He did not listen. Now, the cancer has gone to the brain. He will not survive." Exactly within 2 weeks, he died. So therefore, if you suggest to a patient emergency treatment, the surgery, he would have lived for some more years. He did not take the advice of the doctor. So therefore, the statutory reporting requirements, medico-legal cases, infectious diseases, consumer protection regulations are very important. These are the various aspects which require for a doctor or doctors to follow the guidelines handling medical negligence cases to avoid medical negligence. I hope I have given some aspects on these 3 topics. I have prepared these notes. I'll give it to Praveen Ramchandra. I request your association
Yes,
to
sir.
circulate to the doctors. It will be helpful.
Sure, sir. Definitely will do that.
Thank you very much for requesting me to give a lecture on these topics. Whatever best I could do, I have done it. I hope and trust that I have done justice to the topics. Thank you very much.
Thanks, sir.
Thank you, sir.
Sir, we have a couple of
Questions?
minutes for questions, sir.
Please.
First, my question. If a doctor who dies and the case is still going on, medical negligence, now is dead and that case cannot be defended by him. So will not become one-sided case in his absence.
No, that's why if he dies, the legal representatives step into his shoes. They are required to defend based on the record. The medical negligence based on the record only. So hospital authorities, they will produce the record. In his absence, who are all maintaining, that person can come and give deposed evidence, produce the record, and that record will be the marked as exhibits, evidence, part of evidence. So therefore, doctor role was, Yes, I treated this patient, I conducted the surgery. That's all he can speak. But rest of the things is the documentary evidence.
Okay.
Therefore, the legal representative is not one-sided.
Okay.
Evidence will be there. You have to produce that evidence and speak and justify the action of the doctor. That's all.
Is the legal representative is the doctor's family members or the doctor's colleague in the hospital?
No, the doctor members, their evidence may not be helpful. The evidence of the hospital, which is maintained in respect of that patient, whether it is a medical negligence case or not, disclose the record, which I said no record, how to maintain consent forum, what is the remarks made in the case sheet at the time of surgical table, what is at the time of the surgery, what happened, complications. You have to record all these things.
Okay. So another thing, once the decision is done in say lower court and now doctor is dead, can their legal heirs like family members go for a appeal?
Yes, definitely.
Okay.
They can challenge. They've
Why?
got a right. Right
Yeah.
of appeal is provided to them.
Yeah. Now there is a estate liability for the doctor's family members.
Yeah.
Why can't the liability transfer to the insurance company itself?
Well, it all depends on. That's why the lawyer must tell what is the estate, how many family members. If suppose this will happen, what will be the position of the family members? All these things must be pleaded and placed on record. They make an appeal to the court that more liability must be fixed on the hospital.
Okay. So whenever the patient complains, give a
Employer and employer relations, the vicarious liability
Okay.
is the person who conducted. The hospital cannot run without doctors, merely because doctor is bona fide conduct the surgery and he has no estate at all, or family members unnecessarily they will be liable to pay. For that, you must adduce evidence before the trial court that this is our status, this is our economic condition. Please fix the liability on the hospital, not on the doctor and legal representatives.
Sir, if the patient has not complained against the hospital, he has complained only against the doctor.
No.
The
No,
vicarious
no.
liability comes on its
No,
own.
no. The hospital and both doctor, they must may implead the hospital as a party.
If a patient has not done that, can a
And
doctor
then you can file application to implead the hospital as a party.
as a party? We can do.
Yes, you have got the right to implead the hospital.
Okay, sir. So one of the
Respondent also has got the right to implead the hospital.
Okay, sir. So when Dr. Shailesh is asking, on what grounds can the compensation awarded be challenged? Is there
No,
any-
that once again based on if there is no medical existence, the finding recorded by trial court, you must show that finding is erroneous in the absence of pleading and evidence, contrary to the medical record. These are all the aspects: erroneous finding and error in law. These are the grounds which are available. What is the pleading? What is the evidence? That evidence is not sufficient to hold. The doctor he has discharged his duty properly. Consent is obtained. He has recorded. Yeah, all these things, the patient was serious condition at the time. There may be possibility, even if it is a highly skilled, knowledgeable doctor, some complication may arise on the table. You must have informed. The patient is in a serious condition. It may the adverse impact may be there. That should be indicated in the sheet. These are all the aspects. That's why I read last topic.
Yeah.
What are the care, caution must be taken. You can attack the ground, pleading is not there, contrary to the evidence, finding is recorded, that is no evidence, that is erroneous, and if the compensation awarded in the absence of evidence suffers from error in law. Both the grounds on which you can attack the degree of compensation.
Okay.
Sir, I meant like if it is awarded as 11 crores or 12 crores, can I have some grounds to reduce the compensation? Is there any
No,
precedent case where the
No,
compensation
that may
in
be
the higher
difficult.
court?
No, if it is compensation not based on the guidelines, based on evidence, that may be imaginary figure. If
Yeah,
it is
that's
not,
so.
no, if it is not, it is a imaginary compensation. Computation is not made in accordance with the aspects which are highlighted in the
Yeah,
second
yes, sir. Second lecture.
second
Yes. Yeah.
topic.
Second topic.
That you have to point out. How much he has, functional disability is not there. Functional disability finding is recorded.
Okay.
Compensation awarded 1 crore. Wrong.
Okay, that can be done.
Yes.
Yes.
It all,
Yes.
doctor, it is the lawyer's job.
Yes, sir.
You can challenge.
Dr. Shailesh,
If it is
second,
imaginary compensatory figure is awarded, that
Ah.
can be questioned
Yes, sir.
by pointing out the evidence and the law on the question.
Error in the law.
Error in law.
Sir, Dr. Shailesh can ask his own question. Second question, it is about should we have a separate Medical Negligence Act separating from Motor Vehicle Act?
No, it is not Motor Vehicles Act. It
Most
is
of the platforms are decided. Most of the cases which are precedent are decided according to the Motor Vehicles
no,
Act.
that is multiplier
Like-
method there.
Yes, sir, like-
That's why I told Kunal Shah
Even
case.
negligence is like.
Negligence aspect is there. Criteria I told you, no?
Yes, sir.
Income,
Yes, sir.
the
Yes, sir.
future loss of income. Suppose a person who is unmarried,
Yes, sir.
he suffers.
No, not only the
Marital status
compensation,
is
sir.
gone, and he
No, sir.
requires treatment,
No,
continuous
sir.
treatment.
Not only the compensation, even when the ruling is passed or a judgment is passed, most of it is akin to Motor Vehicles Act.
No, that's right.
Because
Principle. Compensatory law means these are
sir.
the higher the aspects. The
Yes, sir.
service, the see, deficiency in service.
Yes,
Deficiency in
sir.
service is, it may be a part of negligence. Deficiency in service is also a part comes
Part
under
of
the
negligence.
Consumer Protection Act.
Yeah. Because will there a time come for a separate Medical Negligence Act, like a written rule?
Yes, that can also be, you can suggest to the parliament.
We have provisions for that. Okay.
Yes.
Sir.
Because
Yes.
here in medical negligence, most often intention to harm is not there.
Yeah,
Whereas
intent to harm.
drunken driving, there could be a by drinking and driving only intention to harm is there. So we should ask for a separate medical negligence act.
No, I seriously recommend to enact because of the
Exactly.
the number of cases.
Numbers,
The
yeah.
corporate hospitals today pressurizing the doctors, which you will agree with me.
Yes, sir.
The number of doctors, friends like you, told me, I am not going to this hospital because they insist to recommend this test, these scans, and what is that? The thousands of rupees surgery. One patient who came to me, he was not required to the stent to be inserted. He had underwent unnecessarily 3 lakh fee for 24 hours.
So
There are
another,
hospitals now. So they now this kind of cases not doctors should ethically function. Number one, and number two, hospitals there must be a serious regulatory system to be worked on the hospitals today.
sir, another question by Dr. Deepu.
Am I correct, doctor?
Yeah, yes,
The
sir.
Yes, sir.
corporate hospitals today they are doing business. That's all.
Yes.
And
The
lot of
service is not the motor today.
Sir, Dr. Deepu asks, who has to give consent? Is it a person? If
I
the
told you,
person is
no.
not able to
If
give
the
consent,
patient is all right at the time, you can take the consent. If she is unconscious, husband is not there, children are not there, mother, parents, you can take.
if none of them are there, patient is not there. And later,
Guardian.
anybody we get a consent.
Guardian, not anybody.
When
Guardian,
they immediate,
who is taking care. You
okay,
have
who
to
has brought
record
the patient to the
how
hospital.
that consent is valid. You have to record what is the relationship of that person and the patient. You must record it.
For example, sir, some good Samaritan has brought a road traffic accident patient to the emergency. Surgery
Yes.
has to be done.
Then you can say his statement must be recorded.
Okay, but then when the patient's relatives comes,
Then
spouse
immediately,
comes, they object
immediately
to the
you must
surgery.
inform over phone to that person and tell patient is brought here, medical emergency is there. We have to give treatment or surgery. This Samaritan has given a statement. We have seen the condition. Condition is very bad. an urgent emergency surgery required, we are doing it by taking his consent. And patient is not in a position to give the consent. You have to give the consent by telephonically or send by mail, etc., etc.
SMS or WhatsApp or some mail. Phone we may record, sometime may not. If
Yes.
it is also, those people are not at all available for
Not
it.
available, that person who brought, you have to
But
take that
can
consent.
the spouse of those patients come back later and check?
Yes, they can. No, object. How can they object? See, patient, it is your duty. You can't say, I will not treat. Once again, it is a dereliction of duty.
So
Not for medical
doctor,
negligence, you will be held up.
okay.
For not treating a patient, a case can be filed against the doctor, professional.
So at emergencies, doctors have immunity from the not taking the consent.
No, taking consent, person who brought that patient.
So many times,
If he is not willing, you have to inform the.
whom to inform? Nobody is
Inform.
reachable.
Nobody is not available. Then it is a decision of the doctor and the hospital whether to give treatment or not.
Okay. And another thing, sir, Dr. Akshay is asking, unexpected deadly complication, which is documented as a known complication or procedure in the books, if it happens but not explained by consent, how to protect ourselves? It is a known complication, but in consent it was not mentioned. But it's a known complication textbook and all it mentions.
Yeah.
What defense doctor can have?
No, for the defense, you have to record in the case sheet.
Because sir, there will be so many complications can occur.
Yes, that also you must record at the time. That's why if you want to give a treatment, you will ask, or the test will be conducted, or the clinical test will be conducted whether he is a heart patient or not, blood pressure is there or not. Then the more the diabetic patient, more is not advisable to conduct surgery. All these things after giving treatment to that, then you must undertake the treatment or the surgery.
So if there is a government surgeon who found to be negligent, will the government also become a
Yes, why not? Government also, yes.
Okay. And
There's no immunity. There's no immunity for government. Government hospital also government is liable.
So, but who pays the compensation?
Government, both.
Doctor and the
both upon the doctor, depends upon the gravity, the negligence of, if more negligence on the doctor, proportionately you can fix it. Liability can be present.
So if the hospital says we provided all the infrastructure and all, we don't want to pay, they can defend the hospital.
No, they cannot say. If medical negligence is proved, there is no defense for the government or the hospital.
Okay. Sir, another question asked by Dr. Jagannath. This is the last question probably.
Yes.
Patient was in emergency like MI, suggested some investigation. He doesn't listen and he goes and dies. So can the doctor still be sued?
No, you are not given treatment. They have not
You have to
undergone the
document that
test.
he was explained all those.
No. You are not given treatment. You have asked them to undergo the investigation. They have not done. If it is that the risk of the patient, he dies, you are not reliable.
What is the law of limitation, sir? After till what?
2 years, 3 years, I think.
2 years. So should the doctor should start considering the surgery and the profession of the patient? For example, when an actor comes to a plastic surgeon, where the risk of compensation is more, like that we should start assessing the profession of the patient and what kind of surgery is undergoing.
No, I did not follow your question.
So, for example, sir, you gave an example of an actress, the face. The compensation amount was
Rekha Jain case.
Yeah, the compensation amount was more. So,
yes.
Is it wise for a doctors to select the patients based on the profession and kind of surgery they are going to do?
No. That is not permissible.
So, it's
but everything must be recorded. It should be recorded.
Okay.
Procedure must be conducted. Investigation must be asked to get the test tests. There afterwards, if you satisfy that patient is you can give the treatment and conduct the surgery, then only you can do it.
Sir, another question is there are a lot of paramedical doctors when doctor is asking, like a pharmacologist or pathologist who are non-clinical branch people, and they do clinical practice outside their medical college time or something. Is it permissible to do the clinical work when their branch is non-clinical?
No, you cannot. That
And
is
they
a
say,
serious,
due to my MBBS, I can practice.
it is a serious matter. Persons who is not competent is not expected to either treat or give treatment or conduct surgery. Competent person only. That's why IMA registration qualification prescribed under the IMA Act.
Okay. So, out of curiosity, how the retrograde additions are identified on the?
Retrograde in the record, it can be noticed if you after the death, if you manipulate in the insertions are made, it easily you can find out.
Thank you, sir. I think with this we come to the end of the questions. If any other questions, please ask immediately.
There's one more question which has not been read, sir, by Mr. Arun Kumar, Dr. Arun Kumar.
Arun Kumar is more of a political.
Yeah. Okay, I have not read it. Okay, sir. Yeah.
Okay.
Yeah.
So with this, with your permission, can we conclude, sir?
No. I have done my job. It is for you. Who is the Arun Kumar? If you got any question, let him
He
ask.
has a question. I'll read it out, sir. He asks why medical professionals carry such a disproportionate personal risk when comparable errors by lawyers, public officials, police officers, or politicians may not attract similar financial liability.
It's a very, very important question.
Okay, sorry.
A very important question because now there is a immunity for the judges. Immunity is not there for lawyers.
Yes.
But it is high time if they negligent, they must also be, you must bring them under the Consumer Protection Act. Now,
So you agree with that, sir?
yes, definitely.
Okay.
Because of the inefficiency, mishandling, and corruption, and all these things now is rampant.
So IMA should represent with regards to the policymakers, correct, sir? IMA should represent this thing to the policymakers for immunity for like other professionals.
Definitely.
Yes.
They will not bring. I know that.
Yes.
If that is the case, the system, number of judgments which are written by hierarchy is there, but so many families are ruined by rendering judgments, wrong conducting case, wrong legal advice.
Yes. With the permission of President Sir and Secretary Sir, can I go ahead with the vote of thanks? With no further questions.
Yes, sir. Yes.
Yeah. Good evening, everyone. On behalf of IMA Karnataka State Branch and Medical Legal Subcommittee, it's my privilege to propose a vote of thanks to the conclusion of this highly informative and thought-provoking session. First and foremost, I express our profound gratitude to our distinguished speaker, Honorable Justice V. Gopala Gowda, former Judge of Supreme Court of India and former Chief Justice of Odisha High Court. Sir, your lucid explanation of legal principles governing the medical negligence compensation, the continuation of proceedings after doctor's death, liability of legal heirs, and factors determining the quantum of compensation has given us exceptional clarity. Your guidance on documentation, informed consent, professional responsibility, and fair distinction between adverse medical outcome and actionable negligence will be immense practical value to every doctor attending this program. We're especially grateful for the balance, wisdom, humanity with which you address this sensitive subject. Your observation have reminded us that justice must protect the legitimate rights of patients while also safeguarding the medical professionals from unfair conclusion based merely on hindsight. I sincerely thank President Veerabhadraya sir and Dr. Suriraju and Dr. Shailesh, and I extend my appreciation to all members of Medical Legal Subcommittee organizing team and technical staff. And I also thank all the doctors and participants who joined us with this evening, contributed through their thoughts, questions, and active participation. Your presence reflects the medical profession's commitment to the ethical practice, legal awareness, and continuous learning. Once again, I thank Justice Sir. And with this word, I conclude my vote of thanks. Thanks, everyone.
Thank you very
Thank you,
much.
sir. Thank you.
Thank you
Thanks a
very
lot,
much.
sir. Good
Thank
night,
you,
sir.
sir.
Thank you.
I'll send it to you, doctor. You please circulate this.
Thank you,
Sure,
sir.
sir. Definitely I'll do that.